Welcome back, ladies and gentlemen. Our final session for today's Congress is a panel discussion on the role of arbitral institutions in controlling the time and costs of arbitral proceedings. The panelists for this session are Professor Dr. Mohamed Abdel Wahab, founding partner and head of international arbitration, construction, and energy at the Zulficar and Partners law firm. Ms. Chiann, arbitrator at Arbitration Chambers. Mr. Dmitry Dyakin, member of the SIAC Court of Arbitration and partner and co-head of the dispute resolution practice at Rybalkin, Gortsunyan, and Partners. Ms. Ko Chiann, partner at WongPartnership, and Ms. Yoshimi Ohara, partner at Nagashima, Ohno, and Tsunematsu. This session will be moderated by Mr. Toby Landau, QC, Vice President of the SIAC Court of Arbitration and Barrister and Arbitrator at Duxton Hill Chambers, Singapore Group Practice. Mr. Landau, please.
Thank you very much. Welcome to everyone. I start with an apology, and that is I am speaking to you from Pakistan in the middle of an almighty monsoon storm, which you may hear in the background. That has a couple of consequences. Firstly, there will be some loud thunderclaps and lightning, which has not been arranged by the SIAC, but hopefully will come just at the right moment of our discussion. And secondly, I'm in the middle of an electricity cut. So electricity is gone. I have my daughter in the corner of the room pedaling as fast as she can. But if she stops at any point, then there may be some interruption, for which I now apologize. We are faced with some other challenges for this session, which I will quickly enumerate. Firstly, we are the last panel after a long day. There will by now be a rich cocktail of Zoom fatigue, as well as conference fatigue. Indeed, there may be conference allergy. And also, we are dealing with a very well-worn topic. This is a topic that has appeared on conference programs for decades. There is a risk of Groundhog Day. There's nothing that we seem to be able to do to get this topic off conference programs. So we're faced with it, and that's our challenge now. Can we, in the next hour, come up with some concrete proposals so that none of us have to suffer this at a conference again? That's the task. We are going to try and avoid platitudes. We are going to hone in on what are the specific causes of delay and excessive costs. The panel has been mandated to think out of the box, and I'm grateful to all of them because they've all agreed to put their professional careers and reputations on the line. And with that, I will just tell you the structure of our planned session before we open the floor to some brainstorming. The format will be a free-flowing discussion rather than any set pieces. You are all actively, warmly invited to ask questions through the chat function as we go along, and we'll pick up those questions as and when I notice them or anybody else notices them, and we can feed them into the discussion. We will also have 3 polls that we will conduct in the course of this exercise, where we'll pause. I'll call for the poll. There'll be a question that will appear, and you can all vote yes or no on a strictly no names anonymous basis. With that, the structure for the themes that we're going to debate. We've divided this up into a number of different sections. In a sense, it is a search for the culprits for delay and excessive costs. Firstly, institutions themselves. Let me put on record, it goes without saying that anything we say that's negative can't by definition apply to the SIAC. So we're talking about all other institutions. Secondly, we are going to put the gun on arbitrators themselves, costs and delay caused by the arbitrators. Thereafter, we will look at the arbitral procedure, the shape of the process, and how that is exacerbating the problem. And lastly, we will aim at counsel. Again, no members of the panel by definition, but everybody else. And then there may be some general points thereafter. With that neutral introduction, let me turn to the first category of issues, which is delay delay itself, we can come to costs as a secondary point, delay caused by institutions themselves or institutional rules. And we can take this in two parts. Firstly, whether there is a general problem here in terms of general observations, and then we can hone in particular to specific functions that institutions are responsible for. So if I pose the first question, do we now have to, should we review time periods that have been set in institutional rules for institutional activity? Do we have a problem with the way in which institutions currently run arbitrations? And I'll put that as a first question to Chiann.
Thank you, Toby, and thank you, SIAC, for the invitation. It's great to be here virtually. I am physically seated in Hong Kong, but feel like a far distance away from the actual activity, perhaps as far as Pakistan, although my power is working fine. Thank you. So the question is in relation to delays caused by institutions themselves. And we're looking at specifically the time periods generally set by institutional rules. Now, what time periods are we talking about? Are we talking about the time periods set for counsel or the arbitrators or the institutions themselves? Certainly, we have seen a lot of effort by various institutions on setting timelines on the arbitrators. For example, the time periods by which to render an award and similar such limits. When it comes to time periods set for counsel, these time periods have been long implanted in institutional rules with generally the 2-week to 30-day period at hand, whether we're talking about 14, 15 days or 30 days for largely in relation to submissions and in relation to appointment of arbitrators. Now, these types of time periods are quite predictable and those that we've seen over the years. However, the question is, what kind of time periods are there for the institutions themselves? And certainly we'll talk in the later part of our discussion about potential sanctions, but the reality is that there have not been that many checks on the institutions themselves. And this is an area I think that is worth exploring. Many institutional rules will include language such as the court or the president shall appoint the tribunal as a default as soon as practicable. And I think that some institutional rules in our region do in fact say that. And the question is, well, what does as soon as practicable mean? And how long is that? And certainly I appreciate that when in doubt, it's a case-by-case basis, but the reality is that there must be some parameters set. And so I think it's worthwhile to review what kind of review periods we might be looking at for institutions themselves.
Can I just ask you as a follow-up? You've obviously you've got long experience with various institutions, HKIAC and now ICC. How do you think that that would be received by the institutions if they themselves were subjected to specific timelines?
Well, I think it is something that is worth exploring. I know the ICC has included cost sanctions for themselves. Whether they actually execute on it is a different question, but at least there are now parameters for institutions. But I think that there should be, I would think that it would be welcome for institutions to at least have internal guidelines as to how responsive they should be with any email. For example, as with law firms, I think 24 hours, 48 hours at max in responding to an email is the expectation. And then what does as soon as practicable mean for an appointment of a sole arbitrator or a replacement arbitrator? What are we looking at for challenges, consolidation, joinders, many of these big decisions that can take quite a bit of time depending on the complexity of it, but actually can be quite simple as well. And so having expectations for secretariat and counsel within an institution, I think I would hope would be welcome.
Yeah.
Actually, I do echo what Chiann has just stated, because if we take a look at most of the institutional rules, you will see that prior to the constitution of the tribunal, the arbitral institutions actually play a really major role. They play a really major role in determining questions like, is the prima facie objection to jurisdiction well laid out? They play a role in determining questions of joinder and consolidation. They play a role in determining expedited procedure. But a scan of the institutional rules would show that sometimes they don't even say or use the phrase as soon as practicable. It just simply says the registrar shall determine, and it might even be a case where there's a two-step process. The registrar shall determine, should they refer this to the court? So that I do not see any time limits that's currently placed in the institutional rules or in any guidelines for the institutions to make such a determination. And because of that, I would say that in reality, in practice, as counsel, we have seen quite a number of instances where decisions for consolidations, decision for joinder actually come back to us several months later. And that I feel is something that needs to be nipped in the bud. And I always say, if we set time limits for counsel, we set time limits for arbitrators, then we should also set time limits for institutions. And it is not so much of saying that, or trying to, be so strict or something. But I just think that with time limits, people are more disciplined because lawyers are just used to working with the concept of a deadline. So with that, it may help to move the process along. And another point that I wanted to sort of draw on this is that the constitution of the tribunal process, I think also is increasingly taking a long time. It is hard to see, is it an institution side or is it the arbitrator side? Because the arbitrator takes a long time to respond to the institution. So that's something that's worth exploring. And I also note, that some institutions don't actually take any steps to constitute a tribunal until they receive the share of deposits from both parties. And I do question whether that really should be the way that things are, because just the process of constituting the tribunal, surely the claimant's payment of his share of the cost of the arbitration is more than sufficient to cover at least that first stage so that the process can get moving. So those are my
one of the areas that often is raised and has already been raised in one of the questions now is scrutiny of awards. I mean, not naming any particular institution. There is an institution in Paris that begins with I that can take a long time for that process to be completed. So the question, if we take a specific example, how would we deal with that? So are we proposing that's actually a set deadline for an institution that it must scrutinize an award within a particular published time frame? Let me put that to Mohamed.
Hello, Toby. Hi, everyone. It's a pleasure to join you today. I'm enjoying the discussion so far, and let me answer this by saying the following. Now, first of all, we're speaking about the ICC, and we should really
For the record, I didn't.
Yes, but just to be clear about the scrutiny, there are institutions out there who also do what they call soft scrutiny of awards. So even though it's not in the rules, they undertake that. So at least it's important within the rules to have transparency about the process and set time limits. So if scrutiny is being undertaken hard or soft, it is important, whether in institutional practice or in the rules, to provide for that. And if it's hard scrutiny, as in, for example, under the rules of the ICC, it's important to clarify the following. Normally, the parties would receive a message saying the award will be scrutinized in one of the next sessions of the court. That's fine. And the ICC actually, based on the practice, at least what I've seen in 6 years, moves quite expeditiously with the scrutiny. Now, what may give the impression that there could be some time taken to finalize the process is when the award is not approved. And I think we need to make that distinction. When the award is not approved the first time, and sometimes even second time, it may come across to the parties that this is a long and laborious process for scrutiny. But at the end of the day, the whole process is intended to ensure that the award is ring-fenced against potential setting aside measures or so. So to that extent, I think the immediate review is done within a period of, I say, 2 weeks, 3 weeks or so. And then if there is no approval, it may take longer. So if we're taking a measured approach to that, we should be conscious of the point being made is the first review, did the award pass muster or not? And if not, then that may give the impression that it's longer than expected. But what happens behind the doors is that it is indeed interesting to see how quick the teams review in the Secretariat review awards and scrutinize them. And they do that quite expeditiously. Now, what I think we're discussing is that the parties may then get at least an impression of, does it usually take 1 week, 2 weeks, 3 weeks, 4 weeks? I think what could be added by institutions there is an estimate of the timeline so that everyone is well aware of the scrutiny process. Including that estimate would give everyone the needed transparency about the process of scrutiny itself.
But how do you handle that in terms of transparency? Because the more transparent you are, the more risk that parties will get an insight into problematic cases. So you may have the ICC scrutinizing pretty quickly, but the award hasn't come out for a long time. And the only conclusion can be that there's a wrangle between the tribunal and the ICC.
You're absolutely right. And that's why I think the policy is that parties are being kept in the loop about things ongoing, but they're not given a time frame to allow for the possibility, let's say, sometimes a moment of embarrassment when the tribunal's award is not approved in a way. What I think is helpful is that at least could be a time frame in terms of saying the first scrutiny of the award is approved, let's say within 2 to 3 weeks. If the award is not approved for whatever reason, then 2 additional weeks will be added. So you provide a timetable for the parties. And if it takes longer than the initial period, they will get the impression that at least the award has not been approved in the first instance. I think that's probably the best way to do it.
So if we are going to be recommending to the world that there are fixed timelines for institutions, the question then, of course, is sanctions. Yoshimi, what happens if timelines imposed on institutions are exceeded?
Thank you very much. I echo Chiann's and Swee and Mohamed comment. I agree that institution has to impose certain time limit on its own, and it has to be enforced, executed. And to be able to execute, there has to be some penalty. Without penalty, rule is just a rule, and it doesn't really, teeth. So, well, at least, ICC introduced penalty on its own in case they delay the scrutiny process. Again, I do not necessarily know how it is implemented, but again, then coming back to Mohamed's point, transparency will help improve the situation. Transparency by that I mean, first internal rule. If it will be introduced by the institution, it should be published, and where the award is situated at the moment, draft award is situated at the moment, has to be disclosed to the parties so that parties can anticipate when they can receive award, where the draft award is still sitting at the table on the president of the tribunal member, or it has been transferred to the institution and currently institution is reviewing. That disclosure of where the award is sitting is quite important, practically speaking, rather than imposing penalty per se. Perhaps transparency will improve the situation more effectively, because even if the institution set the penalty on its own, introduce penalty on its own, it's really difficult to implement penalty. But the data of in relation to how long institutions take to process the scrutiny, if it is once published, that will have a great impact and that will promote competition among institutions as well.
I'm going to ask Dmitry, can we go further than this soft, friendly touch that Yoshimi is recommending? Can we go further and recommend that institutions should forfeit fees if they breach deadlines, or that there is some mechanism for naming and shaming, with the obvious exception of the SIAC?
Thanks, Toby. Greetings to everybody from Moscow. It's still kind of summer here, although quite getting cold already. So let me first go to general observation of issue of delay. So when we speak to the issue of delay, we should take into account two major problems, two dilemmas. The first dilemma is dilemma between quality and speediness, and the second one is how we view this major problem by eyes of claimants or respondent. When the second dilemma is resolved initially quite easily, because nobody selecting the arbitration clause or institution from the respondent's perspective. Everybody thinks from the claimant's perspective. However, the problem is getting worse when you start arbitration, and here surely most of the respondents have a delay mandate in their pockets and exploiting this strategy quite well. And the institutional rules should address this guerrilla tactics or other techniques. The even bigger problem is with first dilemma, the quality and speediness. And here again, the institution which is based in Paris and starts with I, has certain features which in their minds and probably in the minds of majority help to secure both integrity and quality, including scrutiny. So, and this dilemma is really hard to resolve. Going back to your question, Toby, whether the institutions should go further and impose even stricter sanctions. I don't think it needs to lead to the better process. It's surely, if you have sanctions in place, which might be imposed by institution, and ICC has this tool, although I know that it's not often used. It disciplined the tribunal, arbitrators, and also case managers. And case managers are doing a great job in policing tribunals to produce the award as fast as most practical. So, I don't think honestly that the community is ready for stricter policies, in my view.
Thank you very much. So at that point, I'm going to ask for the first poll to be taken with a question which hopefully, if this all works, you will see, which is to ask everybody, should there be a mechanism for institutions to forfeit fees if they unduly delay in their operations? I think we will pause whilst you all press buttons and we can see how this does. At the moment, the yeses are far in advance of the nos. Obviously, I've explained that this by definition can't apply to the SIAC, which may have affected the voting. So now it's sort of settling down at 86% yes, 14% no. I think we now have a mandate which we can give to those revising institutional rules. There are the results there. Thank you all very much for the first innovation, which hopefully will go some way to removing this topic from the next conference program. The next point I want to raise, which I'll just do very quickly, is still with the firing line on institutions. We've spoken about delay. what about costs of institutions? Is this a problem? And in particular, do we have any issue about sufficient transparency with respect to how institutions charge themselves? Chiann.
Yes, now this is a question that I think many institutions ask themselves, and the quick answer is of course not. There is no question as to what the reasonableness of their administrative fees. And in fairness, and we oftentimes hear about the 2000 something survey that I think Julian Liu had put together many years ago as to the percentage of administrative fees from institutions of the overall costs of arbitration being in the range of 2%. And so certainly this 2% has been largely ignored for most of the conversations involving costs and time in international arbitration. However, the question has been posed as to whether we should be questioning it. And most institution fees are based on a scale, as we know. However, there are some institutions that have taken the extra step as to review their counsel and deputy counsel hourly rates, as well as look at and ask them to bill in the same way law firms bill, or at least count for their hours. And I know LCIA to be one such institution that does that. And the question is, what does that do, and how does that impact the administrative fees of institutions? Certainly, I think getting more information and getting more data is helpful and lends itself to transparency and justifies why administrative fees are set in the way they are. But let's look back and take a step back as to what institutions actually do. How do they spend their time? How do secretariat members spend their time? As we would expect, most of the time is spent up front at the commencement of the arbitration stage, at the appointment of the tribunal, etc. Only when you have these niggly, complicated issues such as complex arbitrations where consolidation and joinder have to be dealt with, or when challenges arise. These are the add-ons to the administrative fees, the outliers. And on average, I think most arbitrations do not face those types of issues. So the question is, what constitutes as reasonable with administrative fees? I think from the outside, most would not question what the administrative fees, for the reasons that I have set out initially, that they're just not significant. But I think it is a useful exercise. And indeed, I think it's a healthy exercise for all institutions to take stock from time to time as to what is being spent and how to deal with their resources. Oftentimes, as we know, institutions have a two-tier review process where deputy or counsel review the work, and then you have an additional layer. That is a lot of time-intensive work for administering arbitrations. And so I think for the health of the institution, it is worth reviewing these costs from time to time.
Thank you very much, Mohamed.
Yes, Toby, I think here in the interest of making concrete proposals, and I fully agree with Chiann on the reasonableness of this, but I think one addition that institutions may consider, which I haven't seen being done by institutions broadly. Imagine you go to a restaurant, you have the menu, some of which you have the price list next to it. So the outliers, as Chiann referred to, for example, challenges sometimes could be reasoned, sometimes not reasoned for most of the time. If you want reasoning, perhaps you're expected to pay more. So if institutions have an annex or a note within which they have a price list on the extra services that could be rendered, this would indeed help the parties identify whether it's correction, interpretation, administering challenges, reasoning on certain matters. All these things, if they're not included in the admin fee, first, the parties deserve to know out of transparency. Secondly, in terms of certainty, they deserve to know the exact fee for that service, which does not fall under the auspices of the general admin fee. So I think to that extent, one of the proposals I could make to institutions, if and to the extent that the admin fee does not cover certain services, it is definitely in line with transparency and an entitlement to the users to have access early on into that price list as to these extra services.
So it'd be an a la carte menu. Anybody want to comment on that before we shift our gaze onto another area? Dmitry?
Yeah, just one brief comment. I just wanted to know that some institutions, probably for marketing purposes or promoting purposes, sometimes even apply zero fees for some sort of type of disputes, especially those who just started. For example, Tashkent Arbitration Center is practicing this and applying zero charges for some type of disputes. And in Russia, it's also quite widely used to reduce in the beginning the fees for the parties in advance if the sum is at stake is big.
Very good. I think at that point, I want to shift our aim to arbitrators. Now, we do this on a no names basis, and people can apply to us after the Congress for a list of names. I want to focus, first of all, on costs, excessive costs of arbitrators, and then to think about perhaps the richer area of delay by arbitrators. On the issue of costs, the question is, do we have sufficient transparency in terms of how arbitrators themselves clock up their hours and charge? Overall, this may not be a major significant amount compared to counsel's costs and the overall costs of the process, but there are still some rather fruity bills that come in from tribunals, and one can't often question them. And as on a tribunal of 3, there's often a disparity between the 3 as to who has actually done the work and who has spent the time just billing. So with that, let me ask Yoshimi.
Thank you very much. You touched on quite sensitive, delicate issue, particularly the work allocation among tribunal members. And if tribunal members work quite collegially and cooperatively, the procedure will tend to be quite efficient. But sometimes, one of the tribunal member doesn't respond, disappear, and sometimes the institution doesn't really recognize, and they realize that fact at the very end when they check the hours each arbitrator spent. So it is true that institutions sometimes collect hours spent by tribunal members, and that information should be collected on a timely basis rather than towards the end of the proceedings. And it will be helpful, it will be shared with the parties, because the party will know how diligently arbitrator is working, particularly at the stage of drafting an award. Thank you.
Swee.
I guess it really depends on how the institutions charges out for the arbitrators. So for certain institutions, it is by the hourly rate of the tribunal. And it is true that that is not something which usually is shared so readily with the parties. It is something that will be shared with the registrar, and the registrar will make the determination. In certain institutions where they charge based on the claim amount, I do know that the institutions do ask the arbitrators to provide the hours they spend, but they don't really use that as a gauge. They're just using that as a rough sense to see, oh, does it commensurate with the amount of skilled fees that you'll be getting? So I guess therein lies sort of the dichotomy, because it's not always the case that a claim which is of a large quantum then necessarily requires more hours to be spent by the arbitrator, because you could have a simple claim based on the loan agreement where it is just calling upon a guarantee, and you could even get maybe early dismissal of the defense if there were sham defenses being raised. And in that instance, if you just simply have a situation where the institution just gives the scale fees, then that may seem excessive. And if you have a situation where the tribunal is very efficient and then the institution then cuts down on the tribunal's fees because they feel that, well, there's only this amount of hours spent, then that is also likewise, you know, a problem. So there is truly a lack of transparency in this. And Yoshimi mentioned sharing or letting the parties know or asking tribunals to put in their hours much earlier and throughout the entire arbitration. That probably is gonna, I mean, I don't have an issue with that because I'm big on, I believe in transparency, but I'm just wondering whether there will be potential repercussions where people then subsequently use that to mount various challenges against various arbitrators and the disparity between the amount and hours spent amongst the 3 arbitrators. So those are
there's precedent for that. There was a challenge against Sir Michael Carr some many years ago in England, because he put in an invoice which said time spent perusing claimant submissions, 20 hours, time spent perusing respondent submissions, 1 hour.
Exactly.
And that led to a challenge. So obviously this is fraught with some danger. Mohamed, should we have a system where arbitrators on a rolling basis are transparent as to how much time they've actually spent?
It's a very interesting point, Toby, and I know the point that where you say that there is disparity between hours sometimes, but let me take it from the other side. We also see situations where the co-arbitrators would like, and I'll be candid, to have their hours aligned. There can't be disparity that much. And so you hear a co-arbitrator saying, X has put in Y hours, my hours are more or less in the same range. So as not to come across having studied the case differently or overcharged or whatever way. And sometimes it's very delicate because the president may have seen that one co-arbitrator particularly has been very active. What should you do? There's really nothing out there that you can do on that point. Secondly, some arbitrators are very good with record keeping. Others may not be doing the same. So the transparency, I think this is to say, I mean, to echo Yoshimi's point, is a delicate area. To what extent should arbitrators maintain a good record of time? I think to the best maximum extent possible. And I think what institutions should do, basically, as a first step, a concrete proposal, is when they see that there is a theme where an arbitrator is not recording their time properly, they should flag it with the arbitrator, take it step by step. I admit I have not come across that situation with institutions at all, and I'm not sure whether there is an internal mechanism. I am aware that sometimes counsel within Secretariat or otherwise may pick up the phone and discuss with the arbitrator, but you don't see communications in writing over this matter one way or the other. So I think part of the transparency is perhaps to include in whatever guidance note, it can't be in the rules really, that arbitrators are expected to maintain a record of time. And perhaps even they can provide at least a format of how the hours or the record of time should look like. Bearing in mind that we have disparity amongst arbitrators and practitioners as to whether you record time by the minute, by a quarter of an hour, by an hour, there is this disparity. So you round up sometimes figures in a way. So I think the transparency we're looking for is giving them a template of what is expected and how they can keep record of their time.
Dmitry, any thoughts on this?
I think Mohamed covered almost all delicate issues, you know, in this. Although he probably didn't touch whether the arbitrator is really in need of any assistant in the tribunal. From my perspective, is you know, of course, if the arbitrator is quite popular and having repeat, you know, many appointments, it's probably even practical to have an assistant and then use this reasonably and properly. Otherwise, I tend to agree with.
Yeah. So then let's shift into even more sensitive ground, which is much, much more interesting. And that is not costs, but delay by arbitrators. Now, here we're going to draw a distinction between arbitrators themselves simply not getting on with it, and questions about the arbitral procedure, which we'll come to afterwards. So the question I want to ask you all now is, what role can institutions play in actually policing arbitrators, prodding them into action, telling them they're going too slow, somehow supervising them? Who would like to shorten their career by going first?
I don't mind going first, but
next.
I'm quite sure it will not shorten my career.
Perfect, perfect.
So I do think that the institutions, like earlier on, we said that the institutions are very active pre the constitution of the tribunal. And then once that happens, the case counsel gets copied on the email. But you don't really see the case counsel, or at least not from the counsel's perspective. We don't see the communications between the case counsel and the tribunal. And I think that is where the case counsel could really make a difference. I think the case counsel should be actually reading the emails, and in situations where the case counsel sees that the tribunal is not taking any steps, not moving along, the case counsel should take the initiative to call the tribunal, check in with the tribunal and say, I see that this case has not been moving for the past, 1 month. Or, if the tribunal doesn't, take steps to set up the first case management conference, I think the case counsel should call the tribunal and say, I think you should set up a case management conference and to suggest this. And maybe it would be appreciated by some of the tribunals, especially certain tribunal members who just have too many cases on their hand, and they are not keeping a close eye enough on all of the cases that they have. I just feel that that is very important, and it's not just during the whole process, but it's also in ensuring the quality of the process, because I think some experienced tribunals would know how to deal with a non-responding respondent and to ensure that all the communications are copied, that no one is dropped out of the email chain. And this is something, again, I think the case counsel can play a part in monitoring, because I have often seen sometimes, let's say if it's a multi-defendant situation, and then you have originally the first 2 defendants copied, and then after that, the 3rd defendant will start dropping them from the email chain, and the tribunal may not notice such things. Of course, as counsel, we would raise it, but case counsel also plays a role. And the other part where I think institutions could really, do something which is very concrete, is to chase the arbitrator on the award if it takes too long on the draft award, and then to make a mental note of certain arbitrators which are in a sense in the blacklist if they are always not responding, and it's just taking a long time in putting forward the draft award. I think the tribunal members should be on the blacklist.
Chiann.
I hope that segue was not intended to put me on the blacklist.
Not at all. Not at all.
But there you go. I agree with what Swee has to say in terms of greater monitoring from the institution. I think there is a fine line, though, in terms of how much the institution has the capacity to deal with that level of monitoring. And again, when we talked about the administrative fees of institutions, and their general caseload of an average counsel is probably in the range of, certainly in double digits, if not, if we look at SIAC's caseload at 1,000 and they have, say, 20 staff member, you can get a sense as to what their inbox might look like. And so the real reality of this is, what can institutions do realistically to monitor and keep a check on what tribunal members do? And I think that it could be done in a more of a perhaps compromised way, where you could have different stages. Now, we were talking about scrutiny of award earlier, and one idea is to perhaps, for those institutions that do scrutinize awards, have a two-stage scrutiny process, where post-hearing, the tribunal has to submit its draft award based on, the procedural history, the party submissions. Certainly, much of that will have been done, or should be done, right around the time of the hearing. And so that would be one stage where the institution could review those typos and just get the procedural history straight. and then a second scrutiny at the end. And so we could stage this type of engagement with the institution to ensure that that the tribunal is similarly pacing itself. The other aspect is, of course, tribunal secretaries, which we won't be talking about much here today, but certainly tribunal secretaries certainly lend themselves to greater efficiency for those particularly busy tribunal members. And some institutions like the PCA and HKIC do lend do offer their secretariat members to serve as that tribunal secretary to help with the efficiency of the process and to have greater monitoring, as Chiann has suggested, by the institution.
Mohamed, should institutions firstly refuse to appoint busy arbitrators in order to control delay? And secondly, more interestingly, should they blacklist arbitrators who are overly delaying and impose a moratorium on any further appointments?
Thank you very much, Toby. I see this in a number of respects. First of all, regarding your first question, should institutions not appoint busy arbitrators? I think we should make a clear distinction between busy arbitrators and being delayed. You can indeed have busy arbitrators, but who are very well organized. So being busy does not necessarily or automatically lead to a delay in rendering an award or administering the proceedings one way or the other. And in fact, here's the conundrum. Parties like very busy arbitrators and at the same time complain about time and costs. It's very interesting. Speaking to counsel and in-house, sometimes they say they are prepared to wait longer for an award to get someone they think they will not get the case wrong with them, which is very interesting. And at the same time, they push institutions to police arbitrators so as not to be delayed. What I have also seen in practice is that sometimes the parties now in timetables with the tribunal in institutional arbitration include an expected, or let's say a time limit to render the award in discussions with the tribunal. Whether this is acceptable to certain institutions or not, that's something else. But I think it's helpful to have this transparent discussion about the arbitrator's availability. So that's why I see busy is distinct from being delayed. But on the other hand, whether institutions should have a moratorium on arbitral appointments if arbitrators are unwarrantedly delayed. I think it's a very delicate question, but if I'm candid and I take off the hat and there's no conflict of interest, I think arbitrators who are unwarrantedly delayed and it's not a one-off time, but have done that on a number of occasions, do need to get this sort of yellow or red card for a while at least, so that they feel that there is a degree of pressure to get their game straight in a way and do the needful. So I think institutions can do that. And that apparently applies to institutions that either appoint or have a confirmation process. But we know that there are institutions out there who don't really have within the rules the ability to reject an appointment by a party. So I think now with the reform of institutional rules, what I suggest is that all institutions should have a confirmation process, not simply an appointment. That's one thing. Secondly, speaking to colleagues from different institutions, they always say this word: institutions have a long memory. And I think if we really read into that, arbitrators should be very cautious when they accept appointments. Institutions do allow them if they see that they're able to handle, but there is a limit. And I think the first line of defense is that for an arbitrator themselves to resist the temptation to take on board more than what they can handle, and then institutions will be able to monitor this and apply the needed moratorium if needed and if there is consistent delay.
Dmitry.
Yeah, I can only echo what Mohamed is saying. You know, I tend to agree that some sort of, you know, probably not yellow, red cards would be an interesting idea, and exchange of this information between institutions probably might be even better. However, again, I think that institutions, even now, taking into account their previous experience with particular arbitrators, even those who are very popular. And I had an experience, quite unpleasant, probably experience, just recently in the summertime, where we had as a council urgent application for certain procedural actions, and the tribunal didn't respond for 15 days, and even after 2 reminds, it didn't respond, and then the institution itself started to chase those arbitrators, and there's the excuse was it's the summertime, we can't do anything with that. Again, in reality, there are busy arbitrators and there are well-organized arbitrators, and especially in the context of investor-state arbitration, that's some busy arbitrators starting with would be even well-organized, simply will be for those would be hard to produce efficient arbitration overall. That's and still the parties for the states would continue pointing such arbitrators. So the problem is has more aspects than we probably think of.
Yoshimi, what about carrot and stick? What about penalizing, naming and shaming arbitrators who delay and giving bonuses for those who are especially efficient?
Yes, I think, not only penalizing arbitrator who are not inefficient, we have to reward arbitrator who are quite efficient. Sometimes some arbitration related organization issue ranking of arbitrator, most prepared arbitrators award or kind of thing. But institution can do that, and institution can, reward the efficiency of tribunal members. Again, difficulty is some of the tribunal members are efficient and some of the tribunal members may not be efficient. So reward system may not work properly in a true sense. But still, if 3 tribunal members, in case of 3 tribunal members, they work together efficiently, there should be some mechanisms to reward them. For example, sometimes, it also depends on remuneration calculation for arbitrators, but usually institutions have some range in terms of remuneration of arbitrators. So institution can exercise their discretion to reward a bit more to efficient arbitrators. That's something attractive to arbitrators as well.
Now, on this point, I'm going to call for the second poll in order to cement our collective unpopularity. And the second poll question is, there should be a temporary institutional moratorium on appointing arbitrators who have unduly delayed the rendering of awards. The yeses are already way ahead of the noes. The yeses are going off the scale at the moment. We should have, of course, another poll now, which is, can you please name names? But we haven't arranged that, so that'll be for next time. And the results are 95% say yes, 5% say no. We will be seeking out the names of the 5%. In order to establish exactly why they have said no, and we will come back to you on that later. So we have another mandate for institutional rule revision, and now we move on to perhaps the most important area, and that is controlling the arbitral procedure itself. This is probably the genesis of delay and costs if a procedure has not been properly controlled. And there's a first conceptual question, which is, again, what is the potential role of institutions in actually controlling the process itself? This comes in 2 stages. Firstly, perhaps more easily, rule revision. So to what extent should rules actually dictate the shape of arbitrators in order to avoid costs and delays? Secondly, more difficult, what about in the course of a proceeding itself? To what extent can an institution actually play a role at that point? So I'll throw that open. Who would like to start? And if nobody does, then I'm going to I'll put somebody on the spot. In that case, Swee.
Hi, yes, I'm trying to get the question 2 off the screen. Yes, I think that in a sense, the institutional rules across the board as they stand now do have a lot of procedure which parties can employ to the case at hand in order to move matters forward. So you do have consolidation of arbitrations, you do have joinder proceedings, you do have expedited procedure, you have early dismissal of claims. You know, all this I think are great innovations and great tools which counsel can and do make use of in the case at hand. Where I think the institutions, and this was something I alluded to right at the start, can help to move the process along is to actually make the decisions quicker. And that goes back to the first point we spoke about, where I say that time limits should be set for the court or for the institution to come back to parties on its decision on joinder, consolidation, jurisdictional challenge, expedited procedure. And on the other part, I also think that the current expedited procedure rules, I think, have been revised recently across the board again to allow tribunals to actually make orders for documents only arbitration. And recently in my practice, I find that a lot more tribunal members having have regard to these rules, which now give them the power to do so. When faced with a party asking for documents only and another party asking for cross-examination, still tend to, you know, say, well, if a party has asked to examine witness, I think I need to give that right to the party. So, and obviously it is the arbitrator who is concerned that that may subsequently, the award may be challenged because a party will say that I'm not given a full opportunity to present my case because you refused the request for cross-examination. So I'm just wondering whether there should be certain things where the rules are amended to set forth a default documents only arbitration. So it's not just something that applies in an expedited procedure where the tribunal could say that, you know, I'm going to order documents only after hearing from both of you, even though one party disagrees. So should you have that as a default such that, you know, it is more for a party to persuade the tribunal otherwise? Because you think about it, I think if the tribunal sees that there's a factual dispute, look at the causes of action, sees how important witness testimony is, I don't think it'll be difficult to persuade the tribunal otherwise to go for a evidentiary hearing with cross-examination. It is the converse that makes it more difficult. Yeah.
Chiann, should institutional rules be amended so that there are defaults, in particular documents only arbitration, so that the presumption is shifted?
Yeah, I mean, I think that in theory, my answer is yes, because that certainly lends itself to a more efficient process. And in fact, if we look at civil law rules, institutional rules from civil law jurisdictions, notably DIS, which has been quite comprehensive in their rule amendments in the last iteration to include quite a bit of innovative, I would say, techniques to deal with controlling arbitral procedure. I think that there should be, in principle, a default to the expedited procedure. But the reality is, I think that we won't get there. I think that it is a step too far to have the default be documents only, 6 months, sole arbitrator, etc. However, I think that there could be soft guidelines, for example, to encourage parties when arbitrators can proactively see that an arbitration really doesn't need to be dealt with in 12 to 18 months, can be dealt on documents only, and certainly as long as the arbitrator gives the parties sufficient opportunity to make their case heard. I would think that there's nothing wrong with encouraging that mode of arbitral procedure, as long as the basics are there, and that is, of course, the reasonable opportunity to give a case, present your case, etc. I think many institutions now in their provisions under conduct of proceedings have added more and more to give some broader parameters and more powers to the tribunal to enable them to do as such. And so I would encourage more tools, whether it be in the body of these institutional rules or as a set of practice guidelines to support the effort of a tribunal to use different tools to move their procedure ahead.
Could it be said, and I say this only, I suppose, with sort of 30 years of experience now of people saying we should have best practices and encourage arbitrators to do things differently. Could it be said that we've now come to the end of that phase of asking arbitrators, gently encouraging them and providing soft practice guidelines in small A5 booklets? Has the time come that we need to do something actually more forthright in order to prevent us discussing this again next year? Dmitry.
Yeah, it's a difficult dilemma. Again, you know, there are many implications here. You know, where what your background is, where you come from which tradition, and so on and so on, and you know, from claimants or respondents' perspective. Again, claimant is interested in integrity and speed, and wants to have stricter deadlines probably and time frames. In most of the Russian institutional rules, there are strict deadlines, and even in some institutions apply you know, very short time limit for urgent applications, 1 day or 2 days, and that you know, creates the tradition probably for the community, and everybody has these expectations. In some other backgrounds and traditions, it's quite different. So again, this is a quite difficult dilemma. From my perspective as a counsel, and I'm counseling more than arbitrating, I think that, you know, I still want and like the flexibility of the arbitration and those tribunal who allows flexibility and staying within the deadlines of rendering award, because in the end of the day, you know, in most of the you think mostly as a claimant from the claimant side, and you expect that the award would be rendered faster than later. So that's my perspective.
Yeah. So now one of the big hurdles we're faced with in trying to do more is due process paranoia. So one of the problems is that tribunals are reluctant to actually force the parties into something streamlined because they are fearful that that's going to seed the beginning of a challenge that will happen later. So the question for you is, what is the antidote to, what's the vaccination we need for due process paranoia? And in asking the question, I'm going to suggest a possible answer in it, and then you can just simply agree. And that is, what about putting in institutional rules so that parties are bound by it when they contract for the institution? A specific provision threatening, or not threatening, but warning, notifying the parties that in agreeing to these institutional rules, the tribunal is given full authority to curtail the process in any way they want in order to save time and costs, and that each party thereby gives up any right of complaint. Of course, that will be subject to enforceability under national law, which would be another question. But that might be a sort of an agreement to a super form of arbitration where you are agreeing to being bashed around a little bit.
Sorry, Toby, I didn't hear you. Did you say, who did you ask the last?
I asked you just as I thought you might.
Exactly, I read your lips. That's what I thought. It's one. Okay. So I like the proposal, but I have to have a caveat for it, because I think the underlying rationale is that you're thinking that you have a good sheriff in place and you're giving that good sheriff that authority. I fear that this may not always be the case, at least in certain types of cases, certain jurisdictions, so whatever. So I'm fearful of giving this tribunal the full authority. Sometimes arbitrators feel that they are gods on Mount Olympus, so this will only fuel them and feed them further, let's say, thoughts about this process. I think it is helpful, but I think it should be subject to a caveat that we reword this a little bit to ensure that they don't have unfettered discretion or complete authority. But I think one way to do it is that arbitrators need to be robust. What I see is that sometimes parties just when you have children, they test the parents in a way, or the arbitrators. They see, can you be robust? You're going to say whether this is correct or incorrect. And some arbitrators shy away from this type of, I wouldn't say confrontational, but straightforward responses. And I believe if arbitrators are transparent and straightforward with the parties, that will help a lot. Let me give you a clear example. Just last week from a case which I'm presiding. So the party was flagging due process paranoia. A hearing must be held, otherwise our rights are breached. Well, we said initially that the hearing may be, but not necessarily held. It's about a phase of the proceedings, so it's not even on the merits. And they said, well, if we don't hold the hearing, there is a due process breach. And we had to render a procedural order justifying under the applicable law. And I, with my co-arbitrators, insisted, my co-arbitrators didn't feel, I said, well, this is an incorrect reading of the provision of the law. And I wanted to include the word incorrect so that the party sees that the tribunal is not fearful of clarifying the position. And believe it or not, the outcome was positive because the party then said, well, we realize that, can the tribunal then exercise the discretion to grant us the hearing? And I think it helps when the arbitrators are forthcoming, candid, and transparent with the parties and do not shy away from taking decisions as and when necessary, after, of course, taking the prudent approach of hearing the parties carefully. But including rules in the institution, and I think I would fall back on Chiann's position, we can have institutional rules that are quite detailed. So you can have a default position where at least a hearing is not necessarily default in a sense. And we've seen the ICA project about the right to a hearing, whether a hearing exists or not. But believe it or not, there are institutional rules till date, which says if a hearing is requested, the tribunal shall hold the hearing at the request of a party. And I think these types of provisions need reconsideration in today's world.
There's a lot more to be said on all these points, but I'm conscious that actually time is slipping away from us. I want to raise one specific point, or specific proposal, which is on costs, and that is the use of cost management conferences. Now, in some systems, for example, in England and also to an extent in Singapore, you can have a case management conference early on where you actually have to set out a budget for the case. And the idea of that is that each side then knows what are the limits of recoverable costs going forward before they start spending. They may have done some spending already. It's not to stop parties from spending, you can't do that, but you can limit what could be recoverable in terms of costs. And that would be a way also of creating a level playing field and a disincentive to spending too much and council billing too much. Is that a good proposal? Any views? Chiann. Oh, sorry, Mohamed. Anybody?
Well,
okay,
I'm happy. Quite short, which is I don't really, and you'll have the other panelists will have to share with me the downsides of it, but I don't really see a downside to it. Certainly, parties, clients are given budgets, and so counsel have full awareness as to what their budget is, and maybe they don't have awareness as the other side's budget, but I think it would be very helpful to lay it all out up front. We have a case management conference, we have a cost management conference, and then that certainly assists tribunals engaging as to how to deal with costs at the end, and there's a much better baseline to work with. So I would be interested in hearing what the downsides are, because I don't really see one.
Mohamed, is there a downside?
Well, that's an interesting question, Toby, and I agree with Chiann. You can't easily identify downside immediately. However, we are assuming that all jurisdictions assume that legal costs can be allocated and that the budget, as we all know, is primarily for legal costs. But believe it or not, there are jurisdictions out there that you cannot award legal costs absent a joint agreement by the parties and a special power of attorney. There are recent decisions there. One example that comes to mind is the United Arab Emirates, the UAE. The courts there have rendered decisions which says to award legal costs, the parties should have a special power of attorney to claim that, and it's by the parties' agreement. So that's one specific jurisdiction. There are, of course, others. So if we do that, I think the downside of it, if I am correct, is probably first, we need to think whether this will have teeth. Is it just an estimate? Is it going to be binding or non-binding? Because if it's non-binding and it's an estimate, then it doesn't really help much. And if it is to be binding, then you need players who are professional, who know what they are doing, and that they can provide proper estimates. And you may have a situation where counsel will tell you, well, I'm working on this case on hourly rates, and that's my engagement. You can't simply ask me to provide a lump sum or an estimate and impact my client's right to claim those costs in the way. So I think the downside of it is that you may have a friction when the tribunal discusses this with counsel, if one counsel may not be that reasonable in taking that proposal seriously. But I give it to you, I think it's a very good proposal to explore.
Now, yeah, Swee, do you want to, I'm going to call a poll on this, and we're running out of time, but I'll ask for very quick comments from the other panelists. Swee?
Yes, I just wanted to say that really the downside is because of the disparity in the respective counsel team. So you have disparity in the way they charge, the disparity of the size of the team. And when you put forward these estimates and they are meant to be sort of, if they are meant to have teeth and they're meant to affect the recoverability of legal costs, then should the tribunal really be looking at, I mean, if someone says $100,000 for this arbitration and the other party says 500,000, so how is that tribunal going to sort of resolve that? And of course, for counsel who charge on a time cost basis, it does present certain challenges vis-a-vis their own clients. So their clients may then use this cost schedule to negotiate for discounts from the counsel. So that to me, from a counsel's perspective, is a huge downside.
Yoshimi?
Yes, thank you. Well, I have to confess that I'm not familiar with this, cost management system, but I can see some merit. But at the same time, it is, we counsel always face the difficulty in estimating legal fees. And managing legal fees quite difficult, partly because it is quite, how should I say, it depends on how the other party will react. And without knowing how the other party is going to react or how the tribunal is going to instruct the parties, depending on these matters, the total cost, total legal fees could vary extensively, and how you can, estimate properly at certain stage of the proceeding, it would be a challenge.
Dmitry?
Yeah, I didn't come across with this, with this technique. I only can add that it's again depends on the background and tradition in our part of the world. Especially for the big cases, nobody really cares about the fees. Everybody cares about the results of the arbitration, but really how much you spend, it's not really proportional to the very often to the in terms of risks to the result.
Until you lose, of course.
Yeah.
Sorry?
Until you lose, of course, the losing party then starts thinking about costs when they have lost the case.
Not really, Mohamed. If you again, if it's a billions of dollars at stake, if you lose extra 10 millions, it's really doesn't make any big difference.
So I'm going to call a poll on this, the third and last poll, which hopefully you will see on the screen. Institutional rules should require early cost management conferences to fix costs in every case. Now, this is more balanced than we've had before. And it's looking pretty even, actually. Not much between Not much between actually, mixture of yes and no. We don't have a clear mandate on this. I think we'll call it there. It's about well, 50-50, 51, 49, 49, 51. So there we are. We've not made any impact on that, and we don't have a clear mandate.
In light of the last two questions, I feel that the majority of those who are answering are probably counsel.
Sorry, I was on mute. We only have a few minutes left, and we haven't addressed many topics. But what I'm going to do now, very unfairly, because it's without any prior notice, is I'm going to ask each panelist to put forward what is their best recommendation to try and get this topic off future international arbitration conference programs. What can we do to really solve it in the end? What's the most important thing? It's been a problem for us for a long time. What are we actually, where's our primary focus going to be? Chiann's just gone off mute.
Let me say the following. Let me say the following. To the extent arbitration cases are not going to be prosecuted on pro bono basis, I fear that costs will continue to be an issue. They will shift in terms of face and how things are addressed with the new generations and the advent of technology, and we will have new cost segments incorporated, perhaps even artificial intelligence related costs. But I fear that it's being a topic always tabled in conferences proves that it's something that continues not only to bother, but continues to be on people's minds. And I think time will tell to what extent that we will continue to tackle the same issues, or we have shifting issues about costs. And my prediction is that we will definitely have a different discussion on costs with the advent of technology, but I think it continues to be an issue.
Yoshimi.
Yes. Can you hear me? Okay. My suggestion is, again, transparency and disclosure of cost and time of arbitration. When it comes to investment treaty arbitration, many investment treaty awards have been published, and that will assist some, practitioners to analyze these awards and see, how much cost has been spent and how it has been spent. Of course, information included in the award is limited, but still that would facilitate the discussions in the field of time and cost of arbitration. So I hope to see more publication of commercial arbitration award, bearing in mind the confidentiality of the parties.
Who would like to go next? Dmitry?
Yeah, I strongly believe in the forces of marketing forces. If you are transparent, if the institution will be more transparent on publishing costs and average time, then inevitably go to issue of competition between those institutions, and then would make them regulate themselves in order to control better costs and better deadlines. So that's probably would be the best effective tool.
Chiann?
Yeah. So I agree with Mohamed that it's going to be a perennial issue. We talk about time and cost of litigation. And litigation has been around for a very long time. And we talk about time and cost of arbitration, and arbitration has been around for a really long time. So in direct response to your question is, how do we get this topic of arbitration conference? I think we need to put it on the blacklist.
And Chiann?
I would say provocatively sanctions, cost sanctions across the board for institutions, tribunal members, parties, counsel, and the like. I think it starts with the clients, I think, but then we can shift the conversation onto why sanctions are unfair, but that might move the dial a bit.
Excellent. Thank you all very much. We've run over time. There was much more to be said. I'm afraid, this will reappear on a conference program again, and so we'll have more opportunity to discuss it further. I would like to thank all the panelists for risking their careers I'd like to thank all the participants and all the people who posed questions. And I'd like to thank my daughter for some very impressive cycling throughout this session. So with that, that concludes our panel. Thank you all very much.
Thank you.
Thank you. Goodbye.
Thank you.
Thank you to all the panelists for such a thought-provoking discussion.